We're joined by a legal practitioner, Eugene Ode. Eugene, many thanks for joining us. We appreciate you for doing this with us. I mean, let's start with, some legalities here. What specific legal grounds is Governor Fubara relying on in his appeal to set aside the High Court's judgment? And just how might this, grounds impact the appellate court's decision? I understand that Eugene Ode joins us now, the legal practitioner, to speak more on just the disbursement for River State. Eugene, I was asking earlier about, specific legal grounds that Governor Fubara may be relying on in his appeal to set aside the High Court's judgment. Would this grounds impact the appellate court's decision?
Well, since I'm not a member of that legal team and I don't also know the full details of the facts that were presented before the Federal High Court and the legal arguments that were canvassed, I can only speak generally as a lawyer who lives in River State and who is abreast with the facts and the issues we are faced with in River State with regards to the subjects in discussion. Now, you would recall that sometime last year, two factions emerged from the River State House of Assembly. Okay, you had the Bright Amewule faction. You had also the Edison Ehie faction. Those factions emerged after the failed attempt to impeach the governor of the state. Now, who was supposed to preside over the House was an issue which led one of the factions to court to determine that, look, we are the rightful people recognized by law. While all that was still going on, yet to be resolved, 27 of them defected from their political party that sponsored them into the House of Assembly. And by the operation of Section 109, subsection 1, paragraph G, the Constitution is very clear that anybody sponsored by a political party who defects while he's still on seat vacates that seat. And taking advantage of that provision of the Constitution, the Edison Ehie-led House of Assembly declared those seats vacant and communicated to INEC to conduct of by-election to fill in those vacancies. It was while that happened, these 27 lawmakers also rushed back to the Federal High Court to stop INEC from conducting by-elections to fill in those vacancies and ask the court to ratify their defection, even though we hear now that that suit has been withdrawn. Now, in the wings of all this, several other NGOs, citizens also went to court seeking the interpretation of Section 109 of the Constitution to the effect that can these 27 lawmakers still be regarded as members of the House of Assembly, considering the fact that there are provisions of the Constitution that are very clear, like Section 99 of the Constitution, which is very clear that unless you're a member of the House of Assembly, you cannot participate in legislative business of the House. In fact, it's even criminal to contemplate such. And such action, if convicted, may land whoever is involved, in prison, all right? And the Constitution also empowers the House of Assembly to continue the business of legislation in spite of vacancies in the House. That you can see from Section 95 of the Constitution. And of course, we hear also that judgment, people have not seen it, the judgment of the Federal High Court took into account, its reasoning was basically because it's saying that the governor presented the budget to a 4-man House of Assembly and that 4 people were not enough number. They didn't constitute a quorum enough to pass the budget of the state. Therefore, every activity, every legislation, or every law passed by those members, particularly as regards the budget, by those people who did not constitute the House of Assembly, in her reasoning, will amount to an illegality. But of course, if I were in that legal team, I would refer the Court of Appeal to Section 102 of the Constitution, which is clear that the House of Assembly of a state will continue to sit whether there is a vacancy in the House or not. Now, the question is that, are there vacancies in the House? Yes. In the eyes of the law, 27 of those members of the House of Assembly are no longer members of the House of Assembly, having been declared vacant. And that fact of their being declared vacant from the House of Assembly has not been determined as we speak. That order declaring them their seats vacant has not been vacated by any court of law in Nigeria. So that is the status quo as it is. So the governor is left with no choice than to work with those who are still in the House. And as a matter of fact, there are just 4 members of the House. And if you want to look at how the Constitution computes quorum, it says 1/3 of all the members of the House. It didn't say 1/3 of 20, 1/3 of 100, or 1/3 of 50. 1/3 of all the members. Now, who are all the members of the House of Assembly? There are only 4.
All right.
And the governor has presented the budget and has passed the budget and has been appropriating the budget based on what those who are available.
So I have to ask you, right? So given the tension between, the federal and state authorities in this case, how does this situation just sort of illustrate the balance of power within Nigeria's legal framework, particularly concerning financial, allocations?
Now, you see, my joy is that the issue of financial appropriation and our fiscal policy, national fiscal policy, is not left in the hands of politicians. Neither is it left in the hands of judges to determine. Everything is spelled out in black and white, particularly Section 162 of the Constitution. The formula for appropriating these funds accruable, to our federation are all worked out there under Section 162. And the Constitution does not give the federal government power to tinker or to tamper with allocations accruable to both states and local government council. The federal government only has power to appropriate funds that are exclusively appropriated and allocated to them. They don't have power to tamper or to appropriate funds accruable to state government. And the Supreme Court itself has rested this matter in a plethora of cases. A case in point is the case of Attorney General of Lagos State against the AG Federation. If you remember, Tinubu himself was, President Tinubu was then the governor of Lagos State. And the full panel presided over by Honorable Justice Owais, JSC, unanimously agreed that the federal government has no business stopping the allocation of any state of the federation. Right. That judgment is a judgment in rem, and that judgment is still alive and extant till today. So I doubt if the Court of Appeal or the Supreme Court is going to say something different from what has already been established.
Well, Eugene, I must say thank you so much for taking out the time this afternoon to just give us a bit more insight into the legal matters concerning Rivers State. We do hope that this is resolved shortly, at least for the sake of governance and for the people of Rivers State. But Eugene, once again, many thanks.